It is our goal that this webinar provides you with a clear understanding of the contents of these agreements, what you're agreeing to, and what, if any, are the risks to your agency. Kaiser, attorney with Hopeful, Phoenix, Bromley, and Robinson, will be joining us. A practicing New Hampshire attorney for the last 20 years, Monica's current practice is focused on civil litigation, real estate, land use, and other transactional matters. For many years as a criminal defense litigator and mental health counselor have allowed her to hone her skills in negotiation, persuasion, and the art of distilling complex information for consumption by regular people, which is one of the reasons that we invited her to join us today. She will explain the provisions of a sample transit agreement and offer practical tips for agencies entering into contractual relationships with app developers.
I never knew, frankly, as a consumer and user of Google Maps, frankly, how much went into inputting the information. As I review this information, I, along with some of you, might be thinking, well, this sounds like a good idea. This sounds like something I want my agency to do, but is it right for my agency? And so I'm here to help you sort of with the analysis of that decision. There is a little trepidation, a little fear about entering into agreements, particularly maybe with big entities like Google, if you're a very small transit agency in a rural area. So we wanted to reassure you in the first instance that this agreement, while it is, a couple pages long, it's about 4 pages long, it's not really rocket science, and it's not a multi-million-dollar agreement that you have to really stress about. We have not found any litigation on it, and I think that is in part because it's an agreement that doesn't involve a lot of money, that doesn't involve a lot of heavy obligations or financial obligations. I think that's also because there's really not an incentive to litigate on either side. For example, if you're the small company, you're probably not likely to take on Google, even if you disagree with something that they may have done. There's a lot of costs involved in litigating against a big company. And you may just say, well, you can imagine a situation where somebody says, but I want to participate and I want this service, so I'm not going to fight with them about the terms of their agreement. Similarly, Google, is a very, very large company, and they're not going to pick on little old you. If you're your small transit agency in a rural area, the cost of litigation for them, it doesn't get them anything. They want your data because they want to make their product user-friendly, so more people go to their website and use their app. So they're interested in getting as many partners as they can, and they're not going to waste their time fighting with the little guy because maybe that agency submitted their data one day late. I just don't see it as a realistic possibility. So that may be part of the reason why we're not seeing a lot of reported cases on these issues. So hopefully that makes you breathe a sigh of relief in the first instance and think, okay, maybe this is something that we could do. We're a small company, but maybe this is a way that we can boost our ridership by making our data available. So anytime you would enter into any agreement with any vendor for anything, and you'd have to execute a contract, presumably you're thinking about some of these things on my list. You're thinking about what your business goals are, what the thing is that the vendor has that you want, whether it's widgets you want to purchase or marketing services you want to purchase, whatever it is, you're thinking about what your business goals are and how much you want the thing that's available to be purchased or the service that's available to be purchased. You should also be thinking about what kind of organization you are. Are you big? Are you small? Are you a private company? Are you a government agency? Are you a tribal entity? Because if you're a government or a tribal entity, you may have some additional boxes to check before you enter into a contract with another company. And then you're also thinking about, well, what do I get from entering into this partnership? What's in it for me? But also, what is it that my agency has to do? What are the obligations? Whether it's how much money do we have to pay, which is usually the case, or like you have here, you're not paying anything, but you have obligations. What do I have to do? How do I have to get them my data? What format does it need to be in? And what are my obligations to keep it updated? And is that something that we can do? Do we have staff who are able to collect that information and maintain that? And then you're thinking about potential confidentiality considerations. Probably not a big issue in this circumstance. but you may run into it sometimes if you're contracting with a vendor for software or any type of situation like that. That vendor may want you to keep the relationship confidential, or they may want you to keep the information that you learn about their product or service confidential. Google, for example, wants to maintain a certain level of confidentiality. You, on the other hand, probably aren't feeling very proprietary about your data. After all, it's simply your transit schedules. You want those pieces of information out there in the world. But in any event, you're thinking about whether there are confidentiality considerations on your end or obligations you have to the other party. And then you're thinking about what your bargaining power is. And I'll make it very simple. You have very little bargaining power in this relationship with Google or with Apple or any of those. The agreements and the services that they're proposing are what they are. You're not likely to be able to get them to change the form of their agreement. The question is, again, it goes back to they may not really enforce certain provisions of their agreement and waste their time chasing after you, but you're not going to have any success getting them to change the language in their agreement, so don't bother trying. And then lastly, what's your tolerance for risk? So this seems to me to be a proposition, again, because you're not purchasing something for a lot of money. You're taking information that you already have, that you already own, and you're sharing it, but you're sharing it for the purpose of getting your information out there on the web to boost your ridership. And on the other side of that is your obligation. Okay, I have an obligation to get my ducks in a row with my data and submit it. And then I have an obligation to keep it updated. So you're weighing those obligations against what you stand to gain from participating in this process. So if any of you have ever seen a transit agreement like Google's and your eyes glazed over on the first page, I understand entirely. That still happens to me sometimes. But to just take you through the sample Google transit agreement, it's like most contracts, okay? So what it does is it defines specific terms that are operative, that are relevant to the type of agreement that's reached. If it were an agreement for widgets, it might define what a widget is. Here, it's an agreement for the sharing of certain data. So it describes the data, and it describes it in one of two ways. It's either basic or enhanced content. It's either static data or real-time data. For our purposes, we're really just looking at the basic and the static data. I'm not going to get involved in the real-time stuff. Some contracts will also define what confidential information is. And it's usually information that's not out there in the world, available in some other format. For example, your trip schedules are not going to be confidential because they're out there in the world. But whatever secret thing Google does to put their information out there on the web, that might be confidential. And if you find out what it is in the course of your dealings with them, that's probably not something that you should be sharing. The next thing that a contract does is it identifies what each party's obligations are under the contract. And you always want to look at the way the contract is drafted to see if it's equal. I notice in the Google transit agreement, it's very clearly lays out certain obligations for the transit agency to provide information in a certain format and in a certain time frame. You keep reading, it doesn't really ever tell you at what point they're going to upload your data, and it doesn't seem to place those kinds of restrictions or time frame information and obligations on them. But, it is what it is. The next thing a contract usually does is it will tell you what it is that it isn't promising. So I was saying one of the things that the contract does is it has a warranty section where you're basically promising that the information that you're giving them is, or more that you own your name, that you own your service mark, that you own essentially the information that you're giving them. And then the contract describes the length of it and how it is that you terminate the contract if you don't want to be in it anymore, or how Google would terminate it if they want to be in it anymore. And then there's usually some standard language about where the contract would be litigated, if it were to be litigated, and what law would apply. And some general things like where you would give notice of any changes that needed to be made for the contract, and that you can't change the contract unless you do it in writing. Those are the general elements of the contract, and they're often going to be in any kind of contract. It's just that certain elements will be a little bit different, but generally the framework is as I've put it out here. On the next slide, we'll consider the specific obligations in this contract. So you're promising to give the Google or the app or Apple, Bing, whoever it is, you're promising to give them your GTFS data, and you're providing them with permission to copy it, distribute it, and create other work from it and display it. Not for all purposes, not so that they can run out and create another transit agency just like yours with your name and logo. You're only giving it to them for the purpose of this service that they are providing you. So you're giving them a license to use your name, your logo, your data, but you're giving it to them for the limited purpose of in connection with the product or service. And again, with respect to your company name, your trademark, your logo, etc., one of the things that you always want to do is make sure that you legally own that information and that it is yours to provide. So when I say that you're giving them that information only for the purpose of this product or this service, so that your logo gets up on Google at your bus stop, you're reserving all other rights you have to your name, your data, your service mark, your trademark, all that sort of stuff. So it's really a very limited license you're giving them to use your specific thing for the reason you want them to use it, right? This is the whole ball of wax. This is the game right here to get your information out there. And finally, as I said earlier, just agreeing to provide the data in a particular format and in a particular time frame, and you're promising to keep the data current. Both sides are agreeing to protect certain confidential information by only disclosing what's necessary to perform their contract obligations. One of the things that you agree to, and that Google agrees to as well, is that there'll be no public statement about the relationship between you and Google without prior written permission. Both parties agree by signing the contract. It says specifically that either side can terminate at any time with certain notice. And then the promises that I talked about and the limitations of liability that exist are also part of the contract. And then, the standard miscellaneous terms. So for your purposes, what are your risks and how do you resolve them? So in terms of your threshold issue is whether or not you have the authority to enter into an agreement and who at your agency has the authority to enter into contracts. I expect you all know who that person is, but at a minimum, you want to make sure that if you are a government agency or if you are a tribal entity, there may be additional hoops you have to jump through in order to get authorization to enter into a contract. Another company, particularly if you're a tribal entity, probably had to deal with those issues before and look at whether you need to go before the tribal council to get authority or what it is that you have to do. Presumably you have a tribal attorney that you work with and you can discuss those issues with them too. You have often some specific concerns about whether you've waived sovereign immunity by entering into other contracts. That's not a question that I can answer for you, but that's an issue that your tribal attorney has likely had to resolve for many other types of contracts. In terms of your trademark, your company name, you just need to make sure that you're a properly formed legal entity. You need to make sure that if you have a trademark or a specific logo, that it's up to date. If you have a logo that you want to protect, you might want to look at getting trademark protection before you just give permission. What if it accidentally belongs to somebody else and you never knew it, right? That's an issue that you would want to resolve before you put that logo out there into use on the internet. In terms of performance, that's all stuff that you can clean up ahead of time by just before you sign the contract, by thinking about how it is that you're going to collect the data that you need, who in your agency is going to be responsible for collecting it and putting it in the appropriate format and sending it to Google, and then who's going to be responsible for making sure that it is kept current and updated. How do you collect the data? For our purposes, with the static data that we're looking at, that's not complicated. You already have that information. But if you go into a situation where you participate in real-time data and you have certain software or equipment that you use to collect that data, you want to be thinking about your obligation to the provider of that software or that equipment to just make sure that you can then take the information you get from that and use it in another way. Again, for the static data, not a problem. Confidentiality should not be a problem. Again, your information, your trip schedules aren't confidential to the extent that you gain confidential information in the course of dealing with Apple or Bing or somebody else. It's just a matter of making sure your employees dealing with those entities understand the obligations to maintain confidentiality. Some of you, if you read an agreement that talks about, like this agreement does, where certain litigation would occur, there's usually a section that says, hey, this agreement is going to be if there's any litigation, it has to happen in California, and the law that gets applied is California law. That may make people very nervous. It's not likely a term that can be negotiated, and it's also, though, not likely to ever present a major problem with this specific agreement, right? For the reasons that I talked about at the outset. This is generally a low risk situation where you're providing information that you already have, uploading it for a limited purpose to meet your business goals, maybe of increasing ridership. Google is not likely to sue you. They know that you don't have a lot of money. There's nothing that they get from doing that. They really want to engage in this agreement so that they can get your data because it makes their product better. And you want to participate in the relationship because your service is improved the more people know about it. So generally speaking, courts, when they look at contracts that do get litigated and they examine these provisions that mandate what type of law applies or what jurisdiction a contract has to be litigated in, most of the time, the general rule is going to be, the parties can agree to whatever they want. If someone wants to enter into a contract with me and they want the contract to be enforced by, Montana law in Montana courts, I don't have to sign that agreement. But if I do, that provision is going to be upheld because generally speaking in this country, you can contract with anyone you want free from government regulation. So unless there's something particularly unfair about a specific term like that, it is what it is. And as we go back to, what terms can be negotiated, you're not likely to be able to change that portion of the agreement with Google or Apple. Now, it's possible if you have a working relationship with Google or Apple and you haven't gotten all your data ready or you're a little bit late uploading some of it, that you may be able to say, look, we're not going to be able to provide this data in 14 days. We need 30 days. Maybe they'll work with you on that if they really want your information. But that's really the only thing that I see in this agreement that's likely to be flexible or able to be negotiated. My guess is all of the other pieces of the contract are what they are. And that brings me really to the last thing is once you have all this information and you've looked at, what do I need to do to get ready to participate in this agreement? What obligations do I have? What can I do to get my ducks in a row before I execute this agreement? Once you have all that information on one hand, and then on the other hand, you look at, what do I get once I sign this agreement? What is the benefit to my agency? You weigh those two things out, and that's your business decision.